All right, let's proceed. Good morning.
Good morning, Your Honors. My name is Attorney Russell Sobelman, and I represent Mr. Carr, the defendant in this matter. Obviously, this is, I would suggest, a unique case. It's a 30-year-old murder case. And one of the major issues I would suggest of the appeal is the speedy trial issue. Here, what happens in 1974, the District Attorney's Office has its arms around the case. They know what's happening. The suspect is known in Mr. Carr in 1974. They knew his whereabouts starting in 1974. He fled Massachusetts and went to Indiana. Promptly upon his arrival in Indiana, he was alleged to have committed an armed robbery or some other crimes, and Massachusetts knew he was in the Indiana criminal justice system. He was incarcerated. I would suggest the record would show that between 1974 and 1997, except for a few intervening periods of time, he was mostly within the Indiana penal system.
Well, but you do agree, at least as, I think the judge found this, that, and I don't know what the evidence was before Judge Brady, but as I understand it, yes, because of the drifter, they did know that he was in Indiana. They sent ultimately an exemplified copy of the arrest warrant, right?
Yes.
And then Indiana, he was tried in March of '75 on the robbery charge and acquitted, and Indiana didn't hold him on that warrant, correct?
Yes, that's correct.
Now, is there any evidence that the Commonwealth was apprised? I mean, when did they learn that he hadn't been held on the warrant? Do we know?
No, I don't think that's in the record. But he was arrested sometime again.
But how would they know that?
Well,
I mean, the judge found that they didn't know anything again until 1994. So I'm just wondering, on what basis do you say that the Commonwealth knew or should have known that he was wandering between the Indiana and Illinois, as I understand it,
that's right,
criminal
too.
justice system?
He was in Illinois as well, I forgot. Thank you. Well, I would suggest that perhaps Massachusetts, after 1975, didn't know his whereabouts for a certain time. But certainly sometime thereafter, shortly thereafter, and much before 1994, if they stayed in touch with Indiana, they would have known where he was.
So, okay. So you're saying it's not that you have affirmative evidence, but you're saying they should have, and we actually don't know what they did between 74 and 94, correct? That's your point?
Yes.
Or 75 and 94?
Correct. I say that, and I also say, Your Honor, that the record's clear. The police actually obtained an arrest warrant for Carr in August of 1974.
And there was a complaint
Then in
also.
October-
Wasn't there a complaint also
Right.
in August?
Yes. Then in October of 1974, the arrest warrant was sent as a detainer, which you referred to. And I would suggest his speedy trial rights begin in October of 1974,
Well, actually, the judge found August of 74, I believe.
even sooner. But certainly not I would suggest, to be fair, it's around that time. He's not even indicted until 1997. They held off.
Well, if we assume that they didn't know where he was until 94, I mean, you can question whether they should have, but they didn't. I don't think there's any evidence that they did, right?
Well, they knew where he was up to 75, definitely.
Right.
And after that time, whether or not they knew up to 1994 is vague. And I would agree with your analysis of whether or not should they have known, what's their obligation. And I'm not sure what their obligation is either. But certainly, They knew where he was, and just with a little effort, they could have found him in Indiana quite easily because it was part of that system. And regardless of whether or not it was Indiana's fault or Massachusetts' fault, it was certainly a governmental agency's fault that Mr. Carr was not brought back to Massachusetts.
I wanted to ask you about that. You cite this Georgia case for that proposition, which cites Loud Hawk. But as I read the Georgia case, it's really talking about the Georgia. I'm concerned about this interstate, this sort of morphing from or going from the Commonwealth of Massachusetts to encompass every state in the Union. I mean, is there any case that suggests government does that? The word government does that?
Yes, I actually have that. I think it's the...
Because I think the Georgia case is pretty clear when you read it. It is talking about the state of Georgia.
Right, but it does that, the Hawk case, and also Hutchins is mentioned as well, where the government, whether it's the prosecutor or the court system, they have obligations with respect to speedy trial. And in fact, the analysis, because I presume this is going to be a question, is even if the defendant was partially at fault or responsible for the delay, that's not really the issue. It's the government, which includes the prosecutor, the court system, or any other state, is more to blame. Here, the DA's office chose not to seek an indictment until the Indiana charges were resolved. Here, they never obtained a governor's warrant in 1974 when they knew where he was. He was never indicted, as I mentioned, until 1997. 23 years later, even though they issued the warrant in 1974, they don't indict him for 23 years. The only evidence that Mr. Carr even knew about the warrant regarding Massachusetts was not until February 13th, 1996.
And what was
So-
that? He learned about it in 96, you're
Yes,
saying?
that's well.
So there's no evidence, in other words, that the defendant knew while he was in Indiana, after September of 1974 and before his release in March of 75, that the Commonwealth was, there was a complaint out of Roxbury for the Matthouse murder. There's no evidence that he knew of any of that?
Right, I couldn't find any evidence in the record.
The judge said, I don't know if he had a basis, but the judge said that he evaded that, and that's when he skipped. I think that's the finding.
I agree he left for Indiana. There's no question. However, at the time he left for Indiana, where's the evidence, I suggest there's none, that he knew there was a warrant for his arrest? But he did skip. I mean, I guess we can't throw common sense out the window, and perhaps he had a feeling or knew, but I don't think officially he was informed. Also, I'm going to break up the speedy trial, if you don't mind, into two parts. I think from 1974 to, we'll say, 1996, 97 is phase one, and then 1997 to 2004 is phase two. And we've discussed somewhat 74 to 96 or 97, but 97 to 2004, I would suggest there was an abuse of discretion by the judges to allow such a delay, as well as by the Commonwealth for not insisting and moving for trial.
Well, Mr. Silverman, I'm sorry to interrupt you on that, but the judge says in his findings specifically that the defendant is not challenging post-indictment. Defendant, I'm quoting here, defendant does not contend that the delay following the indictment is the fault of the Commonwealth.
From what years?
Well, I assume the indictment was in 97, right? And the
Right.
trial was in 2004. Isn't it?
Right.
It's the exact period of time you're
Yes.
talking about.
So, but I still suggest, Your Honor, that certainly the courts because the courts can overrule the district attorney, even if they did insist, but they didn't. But to let it go this long because Mr. Carr kept saying, I have ineffective counsel, they're not doing what I want another counsel, I want another counsel. There comes a point where I think the court can say, it's 2 years in, 3 years in, 4 years in, enough is enough. And they let it go to 2004. So again, his speedy trial rights, I believe, were violated.
When you say enough is enough, but nevertheless, it was at the defendant's request, wasn't it?
I agree. It was at his request because he kept asking for new attorneys.
Yeah, and the court is generally somewhat accommodating when those requests are made.
Yes, they are. I know that.
It could be. We've seen a number of appeals where defendants have claimed that courts were not sufficiently accommodating, and the defendant's Sixth Amendment right, therefore, it becomes an issue.
Well, yeah, it's a balance.
What are we to do?
It's a balancing test. You look at the facts. In this case, there's already been a 23-year delay, and then you add on to that another 7 years, and the court has to balance it. And I think 7 years to find the right attorney is an abuse of discretion. But if you add in 23 years, and on top of that, one other factor which is in the record, this particular defendant had already been to Bridgewater at least, I think it's 2 times. So there could have been some questions. I'm not saying competency or criminal responsibility was an issue, but wanting new attorney after new attorney.
Well, I mean, there's another way to look at that, too, and that is defendant manipulation of the system.
Yes, I
mean,
agree.
So we can also consider that then.
You may, and again, I believe it's up to the court at the Superior Court level, where the case was, to put a stop to it, and say, I'm familiar with your attorney. He or she is an excellent attorney. They've been an attorney for many years. They've been before this court. This court has confidence in them. Mr. Carr, this is your final attorney. And there's no reason why the court could not take that stand after a couple of years.
So how much time from 1997 to 2004 do you say is attributable to or we can reasonably attribute to the defendant?
Well, technically, he always asked for new counsel. So I would say all 7 years is attributable to him because he kept asking. What I'm saying is perhaps after a couple of years, the court, based on its knowledge of some of the CPCS public defenders or the court-appointed lawyers that they were familiar with, should have stopped it.
And that's a question of fact for a judge, for the trial judge?
Yes.
What did the judge say about that?
They kept allowing his request
Well,
until the very last day. I believe the record will show that on the first day of trial in 2004, there was Chris Skinner, and he had a co-counsel, Stephanie Page. And I believe on that day...
Okay.
Yeah, on that day...
Two of the best.
Yes, two great attorneys. And Mr. Carr, on that day, I think, requested from the judge a change of counsel. The judge said, no, it's too late. It's too late. It's too late. Even though I have to say, as much as I admire Mr. Skinner, I believe in this case he was somewhat ineffective for 3 reasons. He really did a great job at the trial, but I'm going to suggest there were 3 things he could have done better and should have done better, and it fell below the fallible attorney standard. One is, and to me the most important one is, Roberta Carr. Well, before I say Roberta Carr, Mr. Carrasquillo was the one of the major witnesses for the Commonwealth. Very, very important witness regarding identification, credibility, everything. Crucial witness. He claims that he knew Mr. Carr because he went to school with his sister, and he called her Anita or Anita. There was some spelling issues. I got an affidavit from Ms. Carr, which basically said she was born in 1974. She was like less than 1 year old when this event happened. She was never in school with Mr. Carrasquillo. If she was called as a witness, she would have taken the stand. They would have looked, the jury could have looked at her, probably guesstimated her age. She could have had a birth certificate and said, I was born in 1974. I don't even know Mr. Carrasquillo. I never went to school with him. I was still in diapers when this happened. That didn't happen. There wasn't even though he did flee to Indiana, they didn't have a consciousness of guilt instruction, which I think could have been very helpful to the jury. And third is Police Officer Cashman was not called as a witness. And that would have been, again, very helpful with the impeachment of Mr. Carrasquillo, because the Cashman police report and Carrasquillo's testimony conflicted.
Were these brought up in a motion for new trial?
I don't think so. I don't think so. I don't think so. So that, with respect to the speedy trial, and he was prejudiced, by the way. Mr. Carr was prejudiced several ways by not having his trial go speedy. 3 civilian witnesses were deceased by the time of the trial. Almost all the police were either deceased or couldn't be located, which would have helped the defendant with respect to impeachment and potential exculpatory evidence, because between 1974 and 1997, there were contradictions. He didn't benefit by the delay, and there was lost evidence as well regarding a rifle which could have produced fingerprints or no fingerprints that had nothing to do with him.
Wasn't there a report from 74 saying it had been dusted or wiped and they didn't find any prints?
Right. That's true. And certain police reports were lost that would have helped with cross-examination or impeachment. The other issue is whether or not the judge should have allowed funds for an expert witness. And on that issue, the judge denied the request of counsel for expert witness. Now, given that this is a 30-year-old case and key witnesses were no longer available, and basically a lot of the evidence was lost, it really became an eyewitness credibility testimony. I would suggest Mr. Carr was entitled to present an expert witness to testify on 30-year-old eyewitness testimony. I think the judge should have allowed that motion.
Well, was the expert going to testify about witnesses' memories of something they saw 30 years ago, or was he going to testify about, or she going to testify about what actually happened in 1974?
No, about memories. It would be expert
And how could they
testimony.
remember? And if I think this is correct, that all the witnesses we're talking about, am I right, sort of knew Honduras from the neighborhood, correct?
Right, that's what they claim. But some of them, when they were interviewed in 74, just called him a black male or said nothing about him. And then in 97, oh, Honduras, I knew him as Honduras and things like that. So again, an expert may have been helpful with respect to that information.
When you say that they refer to him as a black male, are you referring to the way the police officer had written it down in his report, or are you referring to their individualized statement?
I'm actually talking about Mr. Carrasquillo.
But it was in a report, right?
Yes, there was a report that he referred to him as no name, just a black male. Then in 97, he knew all about him. I see that my time is up. Are there any questions?
Thank you, sir.
Thank you, Judge.
Good morning, Your Honors. May it please the Court. Amanda Teo for the Commonwealth. With me is Edmund Zabin, who is the trial prosecutor in this case. Your Honors, I'm asking this Court to affirm the defendant's conviction for the murder of Carlos Matos. Unless the Court has a particular preference, I'd begin with the speedy trial issue. I'm aware that this Court is deciding in Commonwealth v. Butler whether a complaint issued for the purpose of solely supporting an arrest warrant counts for the purpose of starting the speedy trial clock. Regardless of how the Court comes out on that case, I would argue that the defendant here fails to make out a constitutional speedy trial claim just on the familiar rubric of Barker v. Wingo.
So you agree we get to Barker v. Wingo?
Even, certainly, if this Court decides that a complaint issued for the purpose of supporting an arrest warrant does not start the clock, then I think the defendant does not have a constitutional speedy trial claim here whatsoever. As this Court has already pointed out, the defendant, at least before Judge Brady, explicitly said that he was not challenging any of the period of time of quote-unquote delay after 1997 when he was indicted. But when we do get to the Barker v. Wingo factors, he still has not met the...
Well, is there any evidence, starting here, any indication of why the district attorney in 74 decided not to go forward with an indictment and wait for the charges in Indiana to resolve themselves?
There is no indication in the record, Your Honor.
Anything in the evidence as to what happened between March of 75 and March, I think it was March of 94?
There is, Your Honor. There are two letters in the record from correspondence between Indiana Police Department and the Boston Police Department, indicating that the district attorney here in Boston was choosing to wait until the robbery case in Indiana was disposed before proceeding to indictment. I can only hazard a guess that they were thinking that that's the way that they could get a governor's warrant, that they weren't able to get a governor's warrant on the basis of just the arrest warrant.
No, but that may be the case, but it's not clear to me why you would wait.
Unfortunately, there's nothing in the record showing why they chose to do that.
Did they actually choose to do that?
Yes, that's what it...
There is, in fact, a letter. Well, there's a letter in the record to the effect that Bill Powers, the district attorney, is choosing to wait until the charges in the robbery charges in Indiana were disposed. Nonetheless, and also I think Justice Botsford, you were asking earlier whether there was an indication that the Boston authorities knew that he had been released after the burglary charge, after he had been acquitted of burglary. And there is, in fact, a letter to that effect, and that's on page 38 of the defendant's motion exhibits. Nonetheless, Judge Brady concluded, quite fairly, I would argue, that the defendant knew of the charges in Boston at the time he was released from those, at the time he was acquitted of the burglary charge. And I think we can make that inference is fair for a few reasons. First of all, immediately after he's acquitted on the burglary charges, he flees Indiana and he goes instead to Illinois, where he begins using a completely different series of aliases. I think it's a fair inference that a defendant who knows that he's wanted for murder in Boston and that the Indiana authorities are also aware of those charges would then flee elsewhere and use a different set of aliases to avoid being brought to trial here in Boston.
Is that the case where the detainer had been lodged, or is that a different one? That's the one where he was serving a sentence.
This is still back in 75 when...
But the detainer had been lodged and somehow Indiana released him anyway.
That is correct, Your Honor. Exemplified copies of the warrant had been...
What does that mean, exemplified copies?
I think they just wanted ones that were certified by the court, Your Honor.
Oh.
When we say the detainer has been lodged, it wasn't precisely lodged in the terms of an interstate act on agreement on detainers, but there was, in fact, this correspondence and the sending back and forth of the exemplified warrant to the Indiana Police Department and also the district attorney's office there, asking that they detain the defendant after the burglary charge.
Oh, it wasn't lodged at the House of Correction or institution where he was being confined?
That's correct, Your Honor.
Oh, okay.
And it's not clear from the record why that was the case. Certainly, I think the Boston police thought that this was enough to hold him. And there were representations from the Indiana Police Department and from the district attorney there saying that that would be enough to hold him, and then he was released. So although there was a significant period of delay here, the other factors in the Barker analysis militate in favor of the Commonwealth's position. And to conclude otherwise, we would have to ignore the fact that the defendant repeatedly evaded. He not only fled from the Commonwealth, but then he used a whole series of aliases to avoid being brought back on this charge. And in fact, as late as 1994, when our detectives go out to Indiana and interview him at the reformatory, he's still insisting that he is not Rodolfo
But
Carr.
they obviously know that he is. I mean, that's not hidden on to anybody at the time.
That may be the case, but under Barker, the analysis is whether the defendant is asserting his right to a speedy trial, and where he's denying that he is Rodolfo Carr and that he is the one being charged for the murder of Carlos Matos. That in no way can be interpreted as him wanting to be brought back to the Commonwealth on those charges. If anything, Judge Brady is absolutely correct that this defendant wanted anything but to be brought back to the Commonwealth on these charges.
Can you, is there anything to explain why, if the two officers went in 94 and had this conversation with him in his capacity as, I forget, Santos or something, why nothing happened until 96?
There is some evidence. Judge Rouse, when she heard the defendant's Rule 36D claim, made a finding that the officers actually had the warrant in their hand and were anticipating filing the detainer, but did not.
This is in 94?
This is in 94, but did not do so because this defendant denied that he was Rodolfo Carr, and the defendant has not challenged that finding.
Okay, okay.
I would also just like to clarify the record briefly. With respect to the ineffective assistance of counsel claim and the issue of the defendant's sister not being called to testify, I know that Attorney Solomon has repeatedly said that an affidavit is available from the sister. However, that affidavit is not before the court, and he has not submitted that affidavit. So I would submit that there's no evidence here as to what the sister would have testified to. If there are no further questions, I would just like to conclude by arguing that this court should not use its powers under 33E to reduce or nullify the verdict in this case. The defendant shot and killed a 14-year-old boy. He then fled the Commonwealth for over 30 years and attempted to evade responsibility for this crime. Despite his best efforts, a just verdict was returned, and that verdict should stand.
All right. Thank you very much.